On court will proceed. I think I indicated that at this point the court will deal with the evidence of Colonel Stephen Swart. Okay. The word police 6 years detective unit. So the investigating officer in the matter 2018. And he was called Brigadier Nkoko, who assigned to investigate alleged shooting in during the EF Dukashi Stadium in Tanzania. He was further informed that Colonel Mkwali, being the responsible person appointed viral footage that was circulated in camp, and on arrival, and he did so and started to of the interview. 28 July 2018, spent recovered car second was assigned to obtain a up the cartridge and placed in a tamper seal bag as an exhibit in the presence of the witness. Photographs were taken and the reconstruction of where the cartridge casing was picked up was pointed out, and the scene was reconstructed then by Sergeant Punzi of the local criminal record center relating to where the cartridge casing was found. The sealed exhibit bag was then booked into the SAP-13, sealed as Mtansane, and he stated, if he recalls correctly, it being SAP-13-688-2018. He was also informed that the viral footage was forwarded to Captain Mzuko by Captain Mali Govender from the Provincial Communications Office. On the same day, thereafter, a request was made to Captain Mzuko to forward the viral footage, which was on their official handsets, meaning their cell phones, to his official handset, that of his official handset, meaning that of the witness, Colonel Swartboy, for the purpose of extracting and to assist during the investigation process. The footage was forwarded to the witness by Captain Mzuko, and the following day he had sent a request to DPSI East London office to assist in extracting the data, therefore meaning the footage, the viral footage, and to assist with still photos, compiling a photo album from the viral footage. The witness then handed his official handset to Sergeant Francis and Captain Botha from DPSI Digital Lab, Eastern Cape. A request was made to extract the viral footage which depicts accused 1 firing shots and accused 2 receiving the firearm from accused 1, which appeared to be a firearm. The witness received a CD and still photos from Captain Botha in a sealed evidence bag which contained a photo album. The witness also requested now retired Warrant Officer Steenkamp to complete a facial comparison to identify accused 1 and 2, or if possible to identify accused 1 and 2 from the photo album and CD that was recorded. A report was received from Warrant Officer Steenkamp indicating that accused 1 and 2 could be identified via facial comparison methodology. He further added that the exhibits handed to him or received from Captain Botha was also booked into the SAP-13 register at Mtansane police station, or I would say at the exhibit store. On further investigation, it was established that the company, Tactical Security Company, and accused 2 being a part of the company, was contracted to Mr. Malema for security purposes. On that basis, the witness applied for a search warrant at the Durban Chief Magistrate's office, which was granted on the 10th of August 2018. The reason for the application was based on the cartridge casing that was recovered, and therefore to possibly match the cartridge to a firearm or rifle belonging to Tactical Security Company, i.e. Mr. Snyman. The cartridge casing was a .223 caliber. On 11 August 2018, the search warrant was executed. He further confirmed that General, then at the time being Brigadier Govender, had assisted him in this regard. They arrived at the premises of Tactical Security during the morning, and they were later joined by Mr. Snyman. During the consultations, they informed Mr. Snyman they have an authorized search warrant, which was granted by the Chief Magistrate Durban office, and provided him with a copy thereof. Mr. Snyman informed them that he wanted to consult with his attorney first, who happened to be Advocate Carlitz in this matter, who during that time was conversing with Brigadier Govender at the time. Advocate Carlitz informed Mr. Snyman that it was that she had authenticated the search warrant, and Mr. Snyman therefore thereafter cooperated and assisted them throughout the process. He testified that Advocate Carlos diffused the situation, as they were afraid when Mr. Snyman said he is going to phone Mr. Malema. However, this was also diffused by Advocate Carlos. Thereafter the process, Mr. Snyman assisted in providing them with 12 rifles with the same caliber cartridge cases as per the investigation. All the said rifles were sealed in evidence bags in the presence of Mr. Snyman, who also signed for the acknowledgement of receipt of the said search warrant, including the handing over of the 12 rifles. He further testified that the responsible person on the search warrant was one Mr. Mduli, who was, memory conserved, hospitalized at the time, as per the information they received from Mr. Snyman, and that he was the senior director and he was the key holder at the time the search warrant was executed. The 12 rifles was then transported to Brighton Beach Police Station in KZN, where it was booked into the exhibit register and booked out again for transportation to the Eastern Cape Forensic Science Laboratory, Ballistic section. The witness was personally involved in the transportation of the 12 rifles to the Eastern Cape Forensic Science Laboratory, and added that since Mr. Snyman was fully cooperating, he also informed them that all the rifles was not present at the premises, as some had been booked out as per the register, and could therefore only provide them with the said 12 rifles. With the assistance of Advocate Carlitz, they had managed to come to an agreement that the 12 rifles, after forensic analysis, will be returned, and thereafter the next batch will be taken for analysis at the ballistic section, and it happened in that manner. The rationale being to keep the business in full functioning mode. The said 12 firearms was then handed in at the Forensic Science Laboratory in Krueger, and Colonel Mgwadleka received and acknowledged receipt thereof. The IBIS testing would determine if the rifles can be classified as firearms and in terms of the Firearm Control Act, and if it can be linked to any crime or alleged crime, And on completion of the ballistic examination, he was personally involved in the return process of the rifles as per the agreements that were in place with advocates at the time. The firearms were then taken back to Brighton Beach Police Station, where it was handed over to the commander to hand over to Mr. Snyman. With regards to the other 14 rifles that was transported to the Eastern Cape Forensic Science Laboratory, the witness was also involved in that process with the same conditions and process that was followed as per the first 12 rifles that was taken for testing. The witness testified with regards to the transportation of the second batch of the firearms or rifles. He was not personally involved in the transportation thereof. He had received a report that 5 rifles were retained by the ballistic unit in Port Elizabeth and 9 was transported to Brighton Beach Police Station. Thereafter, as per the arrangement, a further 14 rifles were transported to Port Elizabeth for ballistic testing and analysis. After completion of the testing of the last batch, 1 firearm was retained by the ballistic unit and the balance was returned to Brighton Beach Police Station for their handing over to the lawful owner. As testified, the previous 5, he testified that were retained were all returned, save for the 1 rifle that was part of the last batch transported for ballistic testing. The firearm that was retained was CN SPA 249-14. Since the report that he received from the ballistic testing unit was that the said firearm or rifle was linked to the cartridge casing that was found and handed in the SAP-13 exhibit store and analyzed by Warrant Officer Becker of the Criminal Record Crime Science Investigation Unit, also based in Port Elizabeth. There was a further request for the analysis of touch DNA and fingerprint analysis. It, however, was not linked in any manner. That meaning as far as it pertains to DNA and fingerprints, just for clarity. The investigation continued and information was received that Gearhouse Company was contracted by the EFF to erect the stage and provide audio-visual equipment and lighting, music and CCTV footage. A Section 205 Act 51 of 1977 application was made and applied for at Mtansane Chief Magistrate's Office, requesting Gearhouse to make the CCTV footage available for investigation purposes. The said application was granted and Gearhouse assisted with handing over the relevant footage. Brigadier Governor, now General Governor, was tasked to assist in that regard. The footage was provided and still images was provided and a photo album was also compiled or provided. At this point, the witness testified that Warrant Officer Steenkamp stated in a report that no facial identification was possible based on the footage and photo album she had then received as per the request. The witness also requested, SIRA, via the regional manager, Mr. Stander, to establish if Mr. Snyman is registered as a security official with the required authority, which was confirmed, and further established that Mr. Snyman indeed has the required competency certificates to possess a handgun, rifle, and shotgun. It was also established let me not say it was established, but regarding the competency, etc., that aspect I will deal with when the court deals with the evidence of Colonel Janssen. The witness testified that with regards to the viral footage that was downloaded from his official handset, he informed the court that he did not find the source of the viral footage during the investigation, nor the media house that forwarded the viral footage to SAPS and to the social media platforms. The viral footage was viewed, and he could clearly, during the viewing of the footage, see that Mr. Malema in the footage is using a firearm. He confirmed that he is not a ballistic expert, but on the viral clipping one can clearly see the muzzle flash. And due to his experience, during their shooting practices, when they fire live rounds, there will be muzzle flash. Further, the viral clipping, after the shots were fired by Mr. Malema, he then turns as if he is approaching Mr. Snyman, and then there is an exchange of which you cannot see what they are exchanging. However, the gearhouse footage is much clearer. It does have different angles, and one can see to the side of the stage where Mr. Malema is firing shots from the firearm and then turns back again and hands it over. In the short clip, you could clearly see that the second clearly see that there was now also shots fired. The muzzle flash is not clear in the gearhouse footage, and in the view of the witness, the gearhouse footage is clear that the shots were fired close to the place where the cartridge was recovered. He testifies that he is referring to the direction in which all the shots were fired and not the actual spot. The witness testified that on receiving the gearhouse footage was a mere confirmation of the incident of the EFF celebration on that particular day, which was in line with the viral footage that was circulated and trending. After the investigation was completed, all the statements, reports, exhibits, and case docket was referred to the NPA for perusal. Further case dockets registered by other parties were also mentioned, amongst others being the AfriForum. After perusal by the advocate on behalf of the NPA, further investigation was required, and therefore additional statements were obtained from various witnesses at the request of the NPA, including additional reports that were received. Thereafter, statements were requested from Mr. Malema, and prior to the statement, the rights of Mr. Malema was explained by Brigadier Governor regarding the constitutional rights of Mr. Malema. I am mindful that Brigadier Governor was not called. I'm merely repeating the evidence of that witness, but whether it is a fact in dispute will be decided at the appropriate time. After which Mr. Malema had indicated through his statement that he denied the allegation and opted to explain his version in court. The docket was then returned to the NPA, where after subsequent summons known as a J175 were issued with regards to accused 1 and 2 and served on accused 1 and 2. The witness confirmed that with regards to the seal bag and exhibit bag numbers, he had deposed of 22 statements, and on concession by the state confirmed that he cannot from memory recall all the seal bag numbers of each exhibit to which he deposed of. A statement, however, he is able to confirm that while handling the said exhibits, it was not tampered with or attempted in any manner, and all seal bags and numbers remained intact. He further confirmed that there was no tampering with the footage and the chain evidence that followed in any manner. The witness testified that he received the viral footage and it was forwarded to his official handset, his cellular phone, which he uses on a daily basis. He personally handed his handset to Sergeant Francis at the digital lab where extraction was done, and the handset was handed back to him. Since he is not familiar with the processes followed during or after extraction of the data. He is, however, certain that the data that was collected or extracted was indeed correct and kept safe. Therefore, there was no need to leave his handset with Warrant Officer Francis or Captain Botha. The witness confirmed that he had viewed the video footage clips recently, especially the 2 clips received from Gearhouse Company and the footage now termed as the viral footage. The defense at this point had no objection, as the state inquired whether they are accepting the fact that the first 2 video clippings are referred to as the Gearhouse footage and the third clipping being the viral footage, to which the defense agreed, and there was no need to continue questions in that regard. I'll get to cross-examination now. Just 1 second, sorry. You go. Cross-examination by Advocate Holders on behalf of Accused 1. The following is noted. He testified that he cannot comment if it is unusual that a colonel employed by SAPS would be allocated to investigate a docket. However, if a docket is assigned to a detective, then such detective will investigate the docket. He confirmed that he obtained 135 statements. He further confirmed that on arrival at Sisa Dukasha Stadium, he obtained permission from the stadium manager to proceed with the investigation of the premises. This was followed by questions pertaining to the 5 members from the VIP unit that were present and assigned to the protection of Mr. Malema, and as to why he had not testified about it, he replied that it was not deliberate but a mere omission. Thereafter, the names of the 5 VIP members were read out and the statements that they made. The witness testified that he was aware of the 2 members who are based in East London and confirmed that they do not state that they observed anything on the night in question. He confirmed that he interviewed Lunga Mbele, being the individual who scrutinized the tent structure and found no damage. It's also an omission since the investigation of this matter was vast. It continued in this manner, and mention was made of the following persons interviewed who had reported that they had no knowledge of the incident, that being Sergeant Koleka, no persons from BCM or the police. With regards to the reconstruction of the scene, he explained that it was done with the assistance of the lady who pointed out the spot where she picked up the cartridge. He was not able to testify regarding the details and measurements. Apologies. It was put to the witness on behalf of accused. Just a minute. I may have duplicated a page here. Just a minute. Oh. When I refer to this part, Advocate Matthews, it still forms part of Advocate Dowder's cross-examination. I was just checking. I am still getting to yours. It was put to the witness on behalf of accused 2 that the actual firearm in question was not in East London on the date in question, to which the witness could not confirm or dispute. It was not within his personal knowledge. The witness confirmed that DNA and fingerprints were not linked to Mr. Malema in respect of the said firearm. He also confirmed that the house of Mr. Malema was not searched, and he had not found Mr. Malema in possession of any firearm which was not registered to him. Concerning is the following statement put to the witness. I quote, "All right, so we go then to the actual event. You agree that the ground staff that you interviewed after the event were not present during the event on 28 July 2018. I've made a note for myself here mentioning that indeed the grounds or cleaners, the two, were present and attended the actual event on the 28th of July 2018, since they were on duty. The witness replied that he will not know and confirmed that no eyewitnesses came forward to testify that they were SAPS members attached to VIP protection services and had seen anything untoward that night. He further confirmed that the only basis of the complaint is with reference to the viral video footage, and continued to say it was the viral footage that was circulating and that it was twofold, the viral footage and then including the cartridge casing that was linked with the firearm that was presented to the ballistic testing unit. The witness confirmed that he did not know who the person was that recorded the original footage that went viral on social media. He had attempted to search for the said individual, but he was not able to find the person. A reference was made to the 23 statements deposed of by the witness, and it does not mention that he tried to trace the source of the viral footage. With regards to the 23 statements deposed by the witness, I feel obliged to state that it is his evidence in chief, since he was part of collecting exhibits, handing in exhibits, receiving exhibits. For each of those requests, a statement would be deposed of. So 23 statements is not unusual. It's clear that most of them relate to the chain evidence. My assumption. The questions that followed pertained to the handset of the witness, who testified that he had handed his handset to the ballistic unit and informed the member that it was his personal official handset and it was not an attempt to validate the chain evidence. It was part of his investigation. He could not comment on hashtag value, as it does not fall within the expertise of the witness, including the downloading of the footage onto a hard drive. He further explained that after the data was downloaded, he then only directed the forensic unit to extract the two clips that was viewed in court, the two gearhouse clips. It was put to the witness that he is aware that the video footage may be manipulated, and the witness replied that he is not familiar with that concept. Whether manipulation was possible in the year 2018, etc., will be dealt with by court when it reaches the stage of the proceedings. It was further put to the witness that one will get on TikTok, you can put someone else's voice with your picture, and that he knows this happens with memes, with all different things on phones these days. And the witness replied he's not familiar with that type of IT. Once again, I will refer to AI and its inception and when it came to realization at the appropriate time. Sorry? I thought you whispered to me. It was put to the witness then at that point that he cannot say it was not a blank firearm. His reply was, I cannot say it was a blank firearm or not. Advocate Hodes obtained instructions from his client at this point, and on returning, he placed the following statement before the witness after obtaining instructions from his client, and it was phrased as follows: I'm instructed to put to you that the firearm that you see on the video was is what is known as a blank firearm and whether he has any comment. The witness replied, as he had done before, he is unable to say whether it is a firearm, real or otherwise. It was then put to the witness, "You cannot dispute that. Do you agree with me?" The witness replied, "I cannot indicate whether it's a real firearm or not." He also confirmed that he did not mention in his application to obtain a search warrant for the premises of tactical security that the object appeared to be a firearm. That would mean I am referring to the actual application for the search warrant. It was not mentioned that the object appeared to be a firearm. He also testified that he is not aware if any stage/TV firearms reflect muzzle flash. It is not within his knowledge. Photo or Exhibit A3 depicting the scene was shown to the witness, and the content thereof was discussed and placed on record. The witness confirmed what is depicted in the said exhibits pertaining to the scene as correct. Ultimately, it resulted in the question or statement, "You cannot prove the firearm used is a real firearm or not." The witness stated again he cannot comment on the statement placed before him. Cross-examination by Advocate Matthews on behalf of Accused 2. He confirmed that the docket was sent to the perusing state advocate at the time. As far as he is aware, the charges in respect of Accused 2 related to supply a firearm and confirmed that the charges were shown to him. It was put to the witness that no evidence was presented to show Accused 2 contravened the provisions of Section 120, subsection 10A of Act 60 of 2000. The witness stated he hears what is being said to him. He explained that his role was to investigate and to comply with requests, if any, when received from NPA, and he had investigated the matter to the best of his ability. In respect of the count alleging that Mr. Snyman failed to take the required reasonable steps and precautionary measures, the question posed was whether Mr. Snyman created a risk to safety of others, to which the witness replied yes. He also confirmed that Mr. Malema was under the protection of VIP protectors from SAPS, and there were 2 from the Eastern Cape which he knew about. As far as the other 3 protectors, he was told by Brigadier Governor that they were sent by headquarters and he did not interview them. That was done by Brigadier Governor himself. He confirmed that it would be standard procedure that should any offence be committed in the presence of any police official, such official should respond and act immediately. It was put to the witness that this matter is politically motivated, to which the witness replied he is not aware of any such facts and not aware of any political interference in this matter. He confirmed that he is aware of the plea and the plea explanation that was provided in court by Accused 2. And it was further canvassed or placed before the witness that Mr. Snyman denies he ever possessed a .223 loaded Norinco firearm, or that he had a shotgun. In fact, he had a shotgun with a fold-up dash-in butt, to which the witness replied he had finalized his investigation and the facts are before court. The witness confirmed that a list of firearms of tactical security services were obtained by Captain Janssen, and the exhibit is indeed before court and will be dealt with at the appropriate time. He further concedes that if Captain Janssen stated that the SPA 249-14 was booked out to one Larry Mavundla, he accepts it as a fact. He did not personally interview Mr. Mavundla. However, he is aware that a Section 205 Act 51 of 1977 application regarding the movement of Mr. Mavundla via cell phone was obtained and established that he was indeed in East London on the date in question. It was further put to the witness that his client instructed him that Mr. Mavundla flew to East London from Gauteng and therefore he could not have had the firearm with him to fly to East London. Therefore, the firearm was still in Gauteng. The witness confirmed he received the ballistic reports from Colonel Mgwadleka and that a unique mark in the neck was noted and matched to the cartridge, and further put to the witness that the report does not state that there was anything wrong with the firearm, for example, that the breech block was changed, etc. The witness replied he only received the report indicating the firearm was linked to the cartridge that was recovered. It was further put to the witness that surely one cannot just go out and buy spare parts of a firearm. This was not within the knowledge of the witness. I will deal with this statement during the course of further witnesses called. With regards to the video footage, it was put to the witness that it does not depict or show that Mr. Snyman handed a firearm over to Mr. Malema, to which the witness agreed. The witness confirmed that he is aware that the gearhouse footage was inadequate for identification purposes. Therefore, what was left is the viral footage, to which the witness agreed that was sent to his mobile phone. The source, he explained, was not traced. The search warrant application procedure was discussed and questions posed, which was answered adequately. Search warrant being now the premises of Tactical Security Service. It was also put to the witness that Mr. Snyman was not contracted for the protection of accused 1 on that evening. It was the VIP protection unit. The witness again repeated he was aware of the 2 from Eastern Cape. The court will return to that statement made or placed by Advocate Matthews. It was then put to the witness that none of the VIP protectors saw accused 1 firing a shot, which the witness accepted, and further put to the witness that the VIP protectors were on stage with accused number 1. Court will revert to that statement as well. Re-examination by the state of Colonel Rodney Swart. The witness clarified and testified that it was the cartridge that was sent for DNA analysis and not the firearm. Questions by court were as follows. The witness testified that he will not know where the members of the VIP protection unit was placed during the event, and during the interview they had indicated that they were present at the stadium. 2 of the members' statements were obtained by him. However, the other 3, as mentioned, obtained by Brigadier Governor. The 2 members that he interviewed informed him that they were outside, not on the stage or near. However, he was not able to recall clearly. Safe to say that they were present. He is not able to see or identify if these members were on the stage when perusing the video footage. Question based on the court's questions, there was none from the state. Advocate Houders, on behalf of accused 1, the following is noted and placed on record. It was placed to the witness that the close protection officers had to be close to accused 1 to protect him. The witness replied that he does not know the protocol applicable pertaining to close protectors. It was further put to the witness that 2 of the protectors, being 1 Kare and Chauka, said that they were both on the stage at the time. There was none on behalf by Advocate Matthews on behalf of accused 2, and the evidence of Colonel Swart was then finalized. Keep in mind, the evidence has been placed on record to outline what the state then intended or led thereafter in support of the statement by Colonel Swart. Just want to establish which one will be. I will deal, I think, because of time, with the two witnesses which were actually in event very short in nature, and that will be the evidence of Sarel Johannes Krueger. He testified that on 11 August 2018, he was a captain in the South African Police Services stationed at Brighton Beach Police Station, KZN Durban, with 35 years experience in service. On the stated date, he was the Vispol Operations Report Commander that included the management of the exhibits at the station. He confirmed that he received a number of firearms on the 11th, 17th and the 24th of August 2018. He received 22 firearms on the 11th, and on the 17th he received 14 and a further 14 on the 24th of August 2018. The first batch was received by him from Brigadier Govender, who brought the firearms to the witness at the Brighton Beach Police Station. The second batch was received by him from Mr. Snyman himself, and he brought the firearms to the police station as well. The third batch was sent to him by Detective Colonel Swart. With regards to the second batch of firearms that was brought to him by Mr. Snyman, which was 14 in total, and on receiving the firearms, they were all photographed and sealed in exhibit bags, and photos were taken of all the sealed exhibit bags, after which he entered it into the exhibit register SAP 13890-2018. The witness testified that the firearm in question, being the SPA or CN SPA 249-14, was amongst the batch of firearms brought to him by Mr. Snyman in person. The said CN SPA 249 was sealed in exhibit bag PAR 00238-256. This firearm was sent along with the remaining 13 of the same batch to the investigating officer Colonel Swartboy, who signed for the firearms and left with it. The firearms was collected and signed for by Colonel Swartboy on 17 August 2018. The witness further explained that photos was taken during the process, meaning a photo was taken of the firearm, thereafter it was placed in the sealed exhibit bag, and a photo was taken again. The witness was directed and shown photo 40 and 41 and 42 of the photo exhibit album, and he confirmed that the sealed exhibit bag number is the same as the number he testified, being PAR 00238-256. 13 of the firearms of the second batch was returned to Mr. Snyman. However, the CN SPA 249-14 was not returned to Mr. Snyman. He also confirmed that in fact all the firearms in all the batches were returned to Mr. Snyman on various dates, and the only firearm that was not returned amongst all the firearms was the CN SPA 249-14, which he sealed in seal exhibit bag PAR 00238-256. The exhibit was not tampered with, and the exhibit seal bag remained intact. The first batch of the firearms was returned to Mr. Snyman on 17 August 2018, being the batch that he received on the 11th of August 2018. and the balance of all the firearms, with the exception of the CNSPA 249, was returned to Mr. Snyman on 31 August 2018. There was no cross-examination in this regard, and it concluded the evidence of Captain Krueger. As stated, I said I'll deal with the exhibits by the state, or evidence by the state, but since this is also a very short witness, the court will deal with the evidence of Sydney Henry Stander. He testified that on 1 August 2018 he was employed as the regional manager in the Eastern Cape at the Private Security Industry Regulatory Authority situated in Port Elizabeth, shortly referred to as CIRA, and he has been with the regulatory authority for 23 years. He describes that in a nutshell, his duties is the primary objective is to regulate the private security industry by effective control or exercising effective control over the occupation of security in the interest of public and the national interest. During December 2019, he was requested by the SAPS to assist in assessing the profiles of two security officers, being Mr. Xolani Larry Mavundla and Mr. Gerardus Adrian Snyman. In both instances, he was required to access the authority database. Therefore, he was able to confirm the status of their registration with CIRA as well as their training on record with the authority. The court does not deem it necessary to read out the qualifications pertaining to Mr. Mavundla or Mr. Snyman in this regard. Safe to mention that Mr. Mavundla was, according to the CIRA records, employed at Tactical Security Services from 1 December 2017, and Mr. Snyman was confirmed to be registered with the authority since 2004. The skills and qualifications of both these individuals were placed on record. The witness explained that the authority has what is called an intervention team. They are activated upon receipt of any information or complaints of newsworthy value or which would suggest any serious alleged infringements of their provisions. Due to the involvement of a security service provider in this instance, it necessitated their further investigation to determine any non-compliance relevant to their mandate. The court notes that at this juncture, a heated debate ensued between the state and the defense that resulted in the court intervening and adjourning, and on resumption, after further debate and reasons on record, the state had concluded the evidence of this witness, and there was no cross-examination, and by agreement, the statements pertaining to Mr. Larry Mavundla was submitted and accepted by court as Exhibit B1, and that of Mr. Snyman, Exhibit B2, in essence stating that they were both compliant. The court will now deal with the evidence of Colonel David Johannes Jansen. As stated, a Lieutenant Colonel in the South African Police Services stationed at Durban Firearm and Second-Hand Goods Unit, and on 3 August 2018 he had 25 years experience, and he was also on duty on 3 August 2018. He testified that with regards to relevance to the matter before court, He is responsible for firearm compliance, and his duties are to ensure that all people, individuals, businesses, officials, as well as non-official institutions are complying with the conditions under which or for which any firearm license are issued to them. The institution he visited on 3 August 2018 was rendering a security service which are licensed under Section 20 of the Firearms Control Act 60 of 2000, which is dealing with licenses for business purposes, specifically as a security service provider. On 3 August 2018, the witness visited the premises of Tactical Security Services, situated at Lighthouse Road, The Bluff, being a suburb in the city of Durban. The purpose of the visit was to conduct a compliance inspection only. His role and duty was to focus on firearm compliance and the control around it. The request to assist in this regard is contained in his affidavit as paragraph 1.2 and 3, as he was requested by members of the SAPS to accompany them on the set date. He had assigned Warrant Officer Nika and Warrant Officer Small to continue with the inspection of the registers at Tactical Security Services, as he was needed elsewhere. He testified that Mr. Snyman and Mr. Mduli was present at the time of the inspection. He explained that when he refers to Mr. Snyman, it is indeed accused number 2 before court. The witness explained the reason for his presence to the responsible person, being Mr. Mduli and Mr. Snyman. The members started the inspection by checking the registers and by checking their physical record against the records of the institution. I'm sorry. My throat. The witness explains that SAPS has a national database of all firearms that are or has been licensed to any institution or individual. It is also expected from an institution to keep a set of records of all their firearms. He explained that if an institution has a national footprint, meaning it has offices in other provinces, they would have their main stock register at their main registered office, and from that register the responsible person would then delegate the responsibility to whoever is appointed or is responsible at that specific site. Proper written records are required to be kept. The inspection conducted was done over a 2-day period. The institution that was inspected was busy with upgrades at the time, being improving or upgrading the security with regards to the firearms, and when they arrived on the 3rd, being a Friday, and as he had to attend another commitment, they had to continue with the inspection on the following Monday, being 6 August 2018. The total number of firearms, according to the records, were 221 in total, irrespective of the caliber, make, or model. They were all licensed to the institution. There were also no firearms lost or stolen at the institution at the time of the inspection. And since it is known that because of a certain alleged incident that caused the witness to conduct an inspection at the premises of the institution, on paragraph 8 of his statement he listed all the rifles, including the different caliber of rifles, including listing the rifles which were not found on the premises at the time. The witness confirms that the 221 firearms he mentioned were all accounted for in the registers of the institution, including the firearms rifles that have been booked out was accounted for in the registers of the institution. And then as per 826, a copy of the register in an abbreviated combined daily weapons and ammunition register. In paragraph 8, the witness listed the 30 firearms that were not present on the premises. The 30 rifles were accounted for in the register of the institution as being booked out. On the 6th of August 2018, as he was about to leave the premises, he was approached by one Mr. Larry Mavundla, and he brought a .223 rifle Norinco with serial number CNSPA 249, and he had also produced a 9mm Glock pistol with him, serial number YYAYYS 508. The witness was informed by the managers that they are volunteering the firearms as they know that it is viewed as possibly being used in the commission of the offence, and therefore they had asked Mr. Mavundla to bring the firearms to the premises. The witness explained that the offences is referring to the incident of East London, where there was a video clip circulating where Mr. Malema was firing a firearm. Therefore, Mr. Mavundla had been requested to bring the firearms in for inspection and possible ballistic inspection. It was said that Mr. Mavundla was asked to return from Johannesburg to bring the firearms to KZN. The firearm in question was, as he had listed in paragraph 8 of his statement, the .223 rifle, semi-automatic, being a .23 caliber. The said .223 Norinco was marked as number 6 on the list per paragraph 8 of his statement, therefore being the firearm that was presented to him before he left on that day. Thereafter, the witness left and compiled his report. The firearms were left at the institution for whatever further arrangements or investigations that may follow. The 2 firearms brought by Mr. Larry Mavundla was also left at the premises of the institution when they left. The firearms were detained and kept by the responsible people or owners of the institution for presentation to the investigating officer as they may have arranged. The witness also attached a Section 109 inspection report to his statement. It reflects an indication of all the firearms that was physically checked and inspected. The firearms were left at the premises as stated, as the witness was not privy to the investigations and was only requested to conduct the inspection, which he had done, drafted his statement, including the Section 109 report. He confirmed that accused 2 was present on the 3rd and the 6th of August 2018, and also present when he was about to leave and when Mr. Mavundla arrived. He was told by Mr. Snyman that Mr. Malema's personal protector had just arrived from Johannesburg to bring the firearms and to present it to SAPS for inspection. Cross-examination by Advocate Hodes on behalf of accused 1. The witness confirmed he is not a ballistic expert and is familiar with the administrative component of firearm licenses. He also confirms that he has recently been made aware of the fact that replica or look-alike firearms are available on the market, which does not require a license. The witness confirms that some of the replica firearms are available on a website, and I hesitantly quote the name mentioned by the defense and the witness under the search engine, no license needed, end of quote. And that they are also available in a gun store. Some resemble a pistol and others resemble a rifle, even to the extent of it having an extendable butt and that it shoots or fires blank shots. The following statement was put to the witness by Advocate Hodes, and the court will quote from the record verbatim following the above issues. It was placed that these rifles stroke firearms are very authentic. They look exactly like a rifle or a pistol or whatever they are designed to look alike. Do you agree? Will one tell the difference if you look at them in a store? To this statement, the witness replied that obviously he would be able to differentiate based on the fact that it has a gas cylinder, and a pistol is a bit difficult, he must admit, but not the rifle. There's a bit of a possibility of a defraying attribute, if I can use that word, he quotes on page 3 of the record. It is further placed before the witness that even when one fires those pistols and rifles, one gets what is known as a flash, a muzzle flash. The witness replied that he himself has not witnessed it, unfortunately, but he cannot dispute or agree that it may emit muzzle flash. The witness confirmed the statement made thereafter, being that the principle at the moment was that they are available because no projectile comes out of the barrel and no license is required. The witness, however, explained that he has seen this on a website, but has not had any personal interactions or dealing with such a weapon, and had not worked on the reconstruction of such a weapon before, weapon being the replicas found. Cross-examination by Advocate Matthews on behalf of accused 2. The witness confirmed that the inspection he had conducted showed that all the registers were in order on inspection of the institution. He also confirmed that he is aware that the company cooperated and called all the firearms that were booked out in, but that the investigating officer was in communication with the company as to how the firearms will be handled or dealt with. It was put to the witness that indeed they had all come to an agreement that batches of 10 rifles will be handed over for ballistic testing at a time. The witness stated that he was not part of the agreement, but he was aware of such an agreement. He also confirmed that on the 6th of August 2018, as he was about to leave, he was called by Mr. Snyman as a motor vehicle pulled in saying, I quote, here is one of our guys bringing in firearms all the way from Johannesburg. Unquote. It was put to the witness that Mr. Snyman told him, here are the firearms. Do you want to take it for ballistics? And that the witness replied to Mr. Snyman, no, it is not his job. The witness replied that he honestly cannot recall if that was said. However, he can confirm that the male arrived with a pistol and a rifle and that he was there for compliance inspection. It was further put to the witness that it was said in a joking manner that this is the particular firearm that belonged to Mr. Mavundla, and that it was not in East London on the evening the incident happened. The witness referred to paragraph 10 of his statement, and the witness confirmed that it is recorded that they were told that the firearms were brought from Johannesburg. After several questions about the airline and rules, the witness replied by saying that he does not know if or how the firearm got to East London or not. Relevant in the cross-examination is the witness confirmed that the firearm in question, CNSPA 249, the registers of the institution reflected that it was in Johannesburg. It was put to the witness that the specific firearm has a butt that pushes in and not a butt that folds. Further discussions and questions pertaining to the availability of ammunition used by the replica firearms and its legality ensued, and the court does not deem it necessary to repeat the discussion between the defense and the witness on that aspect. In regard to the evidence of Colonel Jansen, by agreement and consent of all parties, Exhibit C being A26 in the docket, the report was then marked as Exhibit C by court. Let's go. Sip of water, then I'll be ready to go with the next one. The court will now deal with the evidence of Dwayne Frederick Francis. I would highlight that indeed the evidence of Warrant Officer or Sergeant Francis was a lengthy process, but in essence I will summarize as best as possible without leaving any detail or important factors raised by either the state or the defense and place them on record. He testified he was a sergeant in South African Police Service in 2018 and attached as an investigator to the Directorate of Priority Crimes Investigations in the Digital Forensic Investigation Unit in the Eastern Cape. He joined the unit in 2013 and received several training concerning computer forensics, mobile phone forensic, and also CCTV footage. I'm not going to list the list of training, it was read into the record. Of importance is he testified that on the 2nd of August 2018 he received a request from Colonel Swart from Mtansane Detective Services to assist him in extraction on a particular phone, and he was also requested to compile a report in that regard. The report was submitted with the consent of the defense and was marked as Exhibit H. Therefore, the relevant exhibit with regards to Sergeant Francis being Exhibit H before court. The nature of the functions performed by the witness was as follows. The mobile phone was handed to him by Colonel Swart on his request to download certain videos from that mobile phone. The video footage was pointed out to him, and he downloaded the video footage with the forensic software at their office. The footage was then copied onto a verbatim DVD. The exhibit was then sealed in forensic exhibit bag, and the evidence bag was handed over to Captain Botha for further analysis or investigation. A copy was also then handed to the investigating officer, and the handset was handed back to Colonel Swartboy. His investigation was then complete. The handset or phone that was handed to him was a Samsung SM-G360H mobile phone with IMEI number 3585-551-06-191340-8. The footage that the witness downloaded was the 2 video clips, and he testified that the phone belonged to Colonel Swartboy. He confirmed that the footage was pointed out to him by Colonel Swartboy, that being the 2 video clips were found on the specific device under the application WhatsApp. Therefore, it is taken from the phone handed to him by Colonel Swartboy. By saying it was found under application WhatsApp, the witness explained that the 2 video clips were received via the WhatsApp application, and he confirmed that whilst the said phone was in his possession, he did not tamper with the said phone in any manner, and further that the footage that was downloaded on the DVD handed to Colonel Swartboy was indeed to the satisfaction of Colonel Swartboy. The DVD was sealed in tamper evidence bag number FSC-1239722, being the DVD marked as Mtansane Cas 0608 of 2018. He further testified that the report he compiled consists of 21 pages in volume, as it explains the procedure that he followed at the office, or the procedure as to how he conducted the investigation on the specific mobile device. The witness was referred to page 19 of his report. This is now by the State Advocate Caesar, to which he testified depicts the photo of the specific handset or mobile phone he used to extract the footage from. And then page 20 contains the relevant DVD that was sealed in exhibit bag number already placed on record, but for record purposes reads as FSC-1239722. That concluded his evidence in chief, and during cross-examination by Advocate Holders on behalf of accused 1, the following is noted. The witness was confronted as to why he did not mention that the specific handset he testified about belonged to Colonel Swartboy. The witness replied he did testify to that regard, which in fact he did in evidence in chief. However, the bone of contention raised by the defense is that it is not specified in his report, and he continued to say that the report states that the phone was handed to him by Colonel Swartboy at his office. Yet the issue remained that the report does not in any clear terms state that the phone belonged to Colonel Swartboy. This led to the following statements made to the witness. As has been the procedure during this judgment, the court will quote verbatim from the record. Quote, you will see here, you say that he approached you. You say in paragraph 6, on the 2nd of August, a request to assist with the extraction of data from this particular mobile phone, which we have already established you never identified as his, that being of Colonel Swartboy. The witness conceded to that aspect in as far as his report does not state it is the property of Colonel Swartboy. He explained that he handed a cellular phone to him, a mobile phone, and it was put to the witness that Colonel Swart told the witness that it is his phone, to which the witness agreed. However, he had also not recorded that sentence in his statement. He explained that he did not ascertain as to who the owner was of the said mobile phone, as the request was to download the video footage and not to ascertain who the owner was. This line of questioning continued for a length of time, and I will, for purposes of this record, have to repeat what was put to the witness, which will clarify the bone of contention and the concessions made during the questioning, and after all then read out the reply by the witness. Read out. The following statements were made to the witness. You see, if one reads your statements and your report, you will see here that you were approached, and you create the impression that you were approached on an objective basis to download all the data from the mobile phone. Nothing could be further from the truth. Do you agree with me? The witness did not have the opportunity to respond, as it was further put to the witness, and the court quotes, "You say that the downloading of all data from the mobile phone was done as set out in your report attached as Exhibit D1. You did not download all the information on the phone, otherwise we would know from your report whose phone it was." The witness replied the request was to download video footage. The statements continued in the following manner. Quote, "Even that is not accurate, sir. You did not download all the video footage on the phone." The witness now, for the first time, replied to these statements made and answered and explains that what has been clear from the onset, the request was received, whatever that may mean. It continued with, "You are not answering the question. I'm going to repeat it again. Nowhere do you compile a report where you downloaded all the video footage on the phone. Do you agree?" The witness replied, "Yes, but the meaning, yes, meaning it does not reflect in the report, not that it was not done." So what happened here, if we can summarize, is Colonel Swart came to you, he gave what was his own phone, which you do not disclose, and he said download all the information which you read to me, and download all the video information which you did not even do. Meaning, at this point, it is put to the witness that he did not download all the information as requested. The witness stated clearly that the video footage was downloaded. Then Colonel Swart pointed out what video footage he is requesting. Advocate Holders then put to the witness, "You have now drawn the distinction. You never downloaded all the video footage. He brought you his phone, he opened a particular WhatsApp and said download this WhatsApp, and that is what you did." The witness replied and explained that is not how the system works. It downloads the video footage in its totality, and then from the downloaded footage, it is where Colonel Swart pointed out the two respective video footages that he requested. The witness was then questioned on if he says it downloads or the system downloads the video footage. Did he then in fact download all the video footage from one WhatsApp on the phone? Because this is the distinction the defense is trying to draw. The witness replied that the video footage falls under the category of media. All media under a folder that includes videos, pictures, and audio. The forensic software only gives one the option to select videos or pictures or audio. Therefore, in this instance, the witness selected video footage or a video folder. It is because he was requested to download video footage. Then, in summary, it was placed before the witness. Therefore, sir, you were directed to one particular video to download, that particular video. The witness again replied, all the videos were downloaded, and from there, the requested specific video footages were pointed out, and that he had stated in his report. Advocate Otis then placed it before the witness. Your report does not come close to saying that, sir. It says the downloading of all data from the mobile phone was done, and that nobody corrupted and tampered with it. And if we turn to your report, he was taken then through the report and with specific reference to page 14 of the report. I quote, to assist with the extraction of data from the mobile phone. The paragraph was read out to the witness and the statement was put to the witness. You did not extract videos. You went to videos and you were directed to a particular video that you then downloaded. Once again, it remains the same statement, phrased in a different manner. The answer by the witness remained the same. I downloaded all the video footage. He, however, concedes that it is not clear in his report. The witness also conceded that his report is not detailed and that he had not stated clearly in good wording that the phone is the property of Colonel Swart. It was put to the witness when testifying. He said that Colonel Swart requested him to download certain videos from the phone. The witness agreed and concedes again that it is so, but it is also not clearly stated in his report. And he also confirmed that he does not know the original source of the WhatsApp, and it is not included in his report that it is a WhatsApp received on a certain date and from a certain person. The witness explained that there is a report that is created by the forensic software that was placed on the DVD. That is the downloading of that specific mobile device which the video footage contains. This was also not accepted by the defense, and it was put to the witness that it does not explain anything. It remains unexplained. But I want to put it to you, sir. One of the most troubling features, because there are several that I have obtained from your evidence in chief, is you said that you made another copy that you gave the investigating officer. The witness stated that that was correct, and on being asked why he had provided a copy of the report to the investigating officer, he testified that it is stated in paragraph 7.3, page 21 of his report, the exhibit and the report were handed over to the investigating officer. Let me just rephrase it clearly. in paragraph 7.3, page 21, states, the exhibit and the report was handed over to the investigating officer, and explained that it means the report and the exhibit being the copy of the information that he downloaded was handed to the investigating officer. Further questions in the same manner, now focusing once again that the report does not state the mobile phone belonged to Colonel Swart. The witness replied and explained all he knows is that Colonel Swart handed over the phone to him, and which he then believed to be the phone of Colonel Swart, and explained to the question to what does he base this on. He explained the mobile phone was not handed over to him in a sealed exhibit bag, as it would be if it did not belong to Colonel Swart. Therefore, it is clear that it belonged to Colonel Swart, because if it did not, then it would be received by him in a sealed forensic evidence bag as per the procedure. Questions return to the fact that when it comes down to the analysis, Colonel Swart was present with him because he directed him to a particular WhatsApp. and as to why it is not in his report, he replied, saying he once again apologizes to the court that he did not provide a detailed description. Further statements followed, which will be repetitive to repeat. Therefore, it was put to the witness that nowhere does he deal with the gist of the case. The witness asked Advocate Hodis if he may explain, and was told which then followed. He was told that the CD that was handed to Captain Botha that was sealed contains the video footage that was downloaded with an additional report of what is used to download the video footage and what type of footage it was, which is the copy is also handed to the investigating officer as the information that was downloaded from the handset. He was then asked to know as to how we will know what is contained in Captain Botha's report. He explained because the DVD contains the video footage and that he downloaded it with a report and an additional report of what software he used to download the record. The witness was asked if he is aware of the value of hashtag, which he confirmed he was, and confirmed it is like a fingerprint to authenticate the forensic information, and he was asked as to where the defense would find that. The witness replied it is found on that CD or DVD that was handed to Captain Botha, and confirmed that it is not contained in his report but in Captain Botha's report. The witness was referred to his report again, paragraph 7.1, stating, I quote, all data found from the above-mentioned exhibit was exported in PDF format on documents to a CD-DVD marked Mtansane CAS 0608-2018 and sealed in a new tamper evidence bag with seal number FSC 1239722, which the witness agreed with. The issue, however, raised by the defense is if it says all data, the witness explained all data should have been said to be all video footage. It was put to the witness, no, that this is an incorrect and false statement. The witness replied that it is the data that was downloaded, as the system does that automatically. Cross-examination by Advocate Matthews. He confirmed that the mobile phone handed to him was functional, and he confirms he recorded in his report that he did not have a SIM card at the time. It was put to the witness, but it cannot work then if it had no SIM card. The witness replied that the SIM card was not needed to work properly, as there was no phone calls made or received for forensic purposes or purposes of his request. He explained on being asked why did he not take it out. He explained that he did not take it out. It is how it was handed to him. He also testified he did not place or insert a SIM card in the mobile phone, and it was put to the witness. He recorded in his statement it had no SIM card. And it was a twofold statement, also stating that he also did not look for one, and if he says he does, how does he know there was none? The witness replied there was no SIM card when he opened the phone and removed the battery. He also confirmed that the forensic system used is Cellbrite. That completed the evidence of Sergeant Francis. Which one? No problem. Do we set a time frame on the comfort break? Or may I ask our police officer just to shout, because I'll come right back in, so that there's no pressure on a time limit to your comfort break. The court will adjourn and then proceed with the rest of the evidence. Just to the state and defense, in that short adjournment before we started, between one and I managed to get hold of some of the people involved, and with the request of going beyond 4 o'clock, I'm told it's not possible. Sorry for that, but it says that it involves so many other sections, units. It's not just, if it was just the court, fine, but it involves many other. Okay, sure we can still get a lot done. We can go back on record. All right, on resumption then, the court will continue with judgment after a few minute comfort break, which we adjourned for. All right. I think I only managed to say the court will now deal with the evidence of Captain Rian Botha. Ne? That's where the state applied to submit the document before court, and the witness started evidence in chief, to which the defense had no objection and was accepted by court, and the document or report marked as Exhibit J. My eyes. The witness confirmed that he was employed by SAPS and on the 2nd of August 2018 holding the rank of captain and stationed at the Directorate for Priority Crimes Investigation for the Digital Forensic Investigation Unit here in the Eastern Cape. The witness processed the place. My eyes are very tired. The witness proceeded to place his qualifications and training on record, and the court is of the view that there is no need to repeat the same, as it is on record at this point and is also contained in Exhibit J. So therefore, on the 2nd of August 2018, he was one of the cybercrime investigating officers at the office. He received a request from the investigating officer, Colonel Swart from Mtansane Detective Unit. The nature of the request was to assist with the analysis of video footage and to compile an album, a verbatim CD sealed in evidence bag with serial number FSC 1239722 was handed to him by Sergeant Francis. The witness was required to do an analysis on the video footage on the CD and to make still photos, compile a photo album thereof, and if possible, to enhance the images on the still photos. Thereafter, to compile a report on his findings. The witness referred to paragraph 9 of his report, where he stated that he opened the undermentioned or the tamper evidence bag and removed the following from evidence bag number FCS 1239772 and removed one verbatim CD R marked as Mtansane CAS 0608 of 2018. The said CD-R was placed in a forensic computer, and all data on the CD was copied onto a 2 terabyte hard drive, HP hard drive, with serial number WCAZAC 779077 for the analysis of the data. The forensic program MP5 was used to do the analysis on the data. The witness then referred to page 10, paragraph 42 of the report, explaining he had done hash values on the CD, meaning he took the CD and went back to the hard drive on which the cell phone data was stored. He then conducted the hash verification from the CD data on the CD to the data on the hard drive, and it gave him an exact match. He explained that since he had copied the data onto the external hard drive and did a hash verification on the data from the CD again to the data on the hard drive, which he copied over, and that gave him an exact match as well. This is contained in paragraph 4.3 on page 11 of his report. The witness then went back and referred to page 9 and testified that the CD, together with the previous tamper evidence bag with serial number or seal number FDC, that must be a typing error, FSC 1239722, was sealed in a new tamper evidence bag with seal number FSC 1239723 and placed in the safe for safekeeping. The witness then referred to page 14 of his report, which contains or depicts photographs of the sealing and unsealing process he followed regarding the said CD. It is depicted in page 14, 15 and 16 of the report. Page 17 contains the conclusion. A photo album was compiled and attached as per RB2. The still photos from album RB2 was enlarged and enhanced by applying filters in the forensic program M5, and a photo album was compiled and it is attached as per annexure RB3. Color copies was shown to all parties in court and referred to page 1 being in relation to RB2. In respect of photo album RB3, it contains some of the photos in photo album RB2 and enhanced it, meaning that the same photos as in RB2, page 1 of the second photo, explaining that it is the same photo on the left and the one on the right is the same photo but an enhanced photo. Then page 2 is the enhanced photo but further enlarged. And the photo in the photo album is reflected from page 1 to page 22. The witness then returned to page 7 of his report, Exhibit J, paragraph 7.3, referring to the album of the enhanced photos, and the 2 video files were copied onto a verbatim CD marked as Mtansane Case 0608-2018 for facial recognition purposes, sealed in tampered evidence bag with seal number PAD 005-06846 and handed over to the investigating officer, Colonel Swart. The CD received from Sergeant Francis, the exhibit and report were handed over to the investigating officer for further investigation. The witness testified that the still images he secured was done from the so-called viral footage made available to him. The witness was asked to explain what he observed in the video footage and explained to court as follows. On page 1 of 10 of the photo album, there are 2 let me put it in this way. The first photos are 2 on the page. It depicts a person and appears if there is a firearm in his hand. Page 2 is still depicting the same person, but now the firearm in his hand is pointing upwards, and it appears as if when looking at the top of the bar, it is going sideways, and it appears as if there is muzzle flash from the firearm. The witness stated he is not an expert in the field, but understand muzzle flash to mean a flame that is seen coming from the front of the firearm. Page 3 still reflects or depicts the same person with the firearm in his hands, pointing up. Page 5 is the same person that had the firearm in his hands. He turned around and walked backwards. Page 5 still depicts the same person. Page 6, the same person that had the suspected firearm in his hands, and he is now talking to somebody. Page 7 shows the same. Page 8 shows a male walking away from the first person shown on the first few photos. Page 9 and 10 is the same person that is walking away. The witness was asked if he is able to identify the persons on the still photos and the enhanced photos, and he replied he is not a facial expert, but from a layman's eye he is able to say that the two persons depicted in photos 1 are accused 1 and 2 before court. The witness further testified that page 10 of his report refers to the hash values, and in paragraph 3, the last paragraph, it is the created time. He explains that when one takes the first two, it is a logical report, that is the Cellbrite report, downloaded by Sergeant Francis, and the last 4 rows is the 2 video footage folders that was downloaded. If one looks at the first one, it was downloaded onto the external hard drive by Sergeant Francis on the 2nd of August 2018 at 01:18:17 seconds p.m. and it was created on the CD on the same day at 01:21:33 seconds p.m. Then page 11 of the report, he copied it over onto the external hard drive, and the same day at 01:42:17 seconds, he also explained that the seconds will differ slightly as it takes a few seconds to download or copy the files. He testified that he had followed the procedure with regards to accused 2 as the person depicted on the photos, who had also interacted with the first individual he had testified about, and in his view it was accused 2 before court. He continued to say that in his view the person who fired the shots as depicted in the footage and image was accused 1 before court. Cross-examination by Advocate Holders on behalf of accused 1. The witness confirmed he was not a facial expert and also not a firearm expert regarding explanations pertaining to muzzle flash, and also cannot venture on whether it is indeed a real firearm or not, including whether the individuals spoke to one another. The witness confirmed that he had received a verbatim CD from Sergeant Francis for analysis, further that he had then downloaded the CD contents onto an external hard drive. He also confirmed that he then determined the hashtag values, which he found to be an exact match. The witness was referred to page 9 and 10 of his report, being Exhibit J. It was put to the witness that on page 10 it states, and the witness explains what is phrased as follows: you took the hashtag values of the files from the download of the mobile phone and copied, and files copied to the CD, showing that it is an exact match. And onto that statement, the witness confirmed that it was indeed correct. It was put to the witness that he did not have the mobile phone. All he had was the product of the mobile phone on the CD. So therefore the chain begins at the CD. The witness explained that his chain begins at the point of the hard drive. The investigating officer and when Sergeant Francis copied the data onto a hard drive, and he first then did the hash verification from that hard drive to the CD, and then from the CD to his own hard drive again. The witness was handed a report being Exhibit H, and it was put to the witness I'm challenging you, sir, to show us where you found that he downloaded the information to an external hard drive. The witness confirmed that it's not contained in Exhibit H, which was also confirmed by Sergeant Francis. A further statement was put to the witness. You are comparing that to a hard drive that we do not know when, where, or by whom it was created. The witness asked if he may explain, and the defense allowed him to do so. He explained that all data downloaded at the cyber forensic unit is kept on hard drives. They do not have other storage facilities, so all data is kept on external hard drives in the safe. So he downloaded the data on a hard drive, and that is the hard drive which he then took to see if it compares with the data on the CD. Advocate Hodes proceeded to make the following statement. So you match the hard drive to the CD, and that we have in pages 10 and 11, and the hashtag values match, and you have got the specific times there, and you can see they are only minutes apart, that they were created minutes apart, and it was quoted 01:18 to 01:21 p.m. as per page 10, and when looking at page 11, it was quoted to be 01:21 to 01:42. The witness then pointed out that the times mentioned is actually the seconds apart, not minutes, and page 10 states the first one is a logical report PDF that is on the hard drive. The second one is a logical PDF report that is on the CD. So you will see the minutes are different because after he had it on the hard drive, he cut it onto a CD. So the times will be different, and then every second one is the CD, and every other one is from the hard drive. The further statement to the witness is the crux of the issue is you define what the hashtag value is and the significance of it, and yet I'm going to give you the reference, Captain. It is in paragraph 5 of your report, page 16 of the record, and the court quotes. And you say here, what is MD5? An MD5 message digest algorithm was developed by Professor Ronald R.L. Rivets at MIT in 1991. MD5 is an algorithm that is used to verify data integrity through the creation of 128-bit message digest from data input, which may be a message of any length that is claimed to be as unique to the specific data as a fingerprint is to the specific individual. In other words, that is your guarantee that that is the exact same information which the witness confirmed to be a correct statement. The witness confirmed that he had matched the hard drive to the CD, but never ever had access to the mobile cellular phone. And in other words, it was then put to the witness, the chain is intact as illustrated by the hashtag values from the CD to the hard drive, but nowhere before that and nowhere after that. The witness agreed in that he did not do a hash verification on that aspect. further paragraphs pertaining to how algorithm was read into the record, and in essence it was then put to the witness that, so here we have a chain that is intact between these two items, the CD and the hard drive, but no hashtag value was obtained of the cellular phone, which the witness agreed with. However, that was not the situation from his side. What followed was statements dealt with during the evidence as testified by previous witnesses, to which the witness had no comment and was not within his knowledge. Safe to add that the witnesses replied by saying that from his experience they also download, or he also downloaded, the mobile phones. On a report of the mobile phone, if we download the data onto a hard drive, you cannot change any of that data, and there must be a hash verification on that report from the Cellbrite facility. We all know that is not available in Exhibit H. Have energy for the next witness? Me or the witness? Time. Shall we call time then? The next witness is 1, 2, 3, 4. The next witness is 5 pages. But it contains quite a few exhibit seal numbers, and my eyes aren't playing along anymore. I can do it. It's Philip Becker that I'll be dealing with. Speak up or forever hold your peace. Okay, you have not held your peace, Advocate Odez? No, I. All right, then I'll play. Advocate Caesar, let's go. Court will deal with the evidence of Philip Rudolph Becker. The witness is a member of South African Police Services, holding the rank of warrant officer and attached to the Provincial Crime Office in the then Port Elizabeth, with, at the time of his evidence, 30 years and 9 months experience, of which 22 years and 8 months experience as a crime scene investigator. The witness explained that his duties are as follows. He is a criminal expert and functions as a crime scene investigator as well as a laboratory technician. It entails the processing of crime scenes for forensic evidence, which includes fingerprints, DNA, ballistic evidence, as well as other impression evidence such as shoe prints. The witness testified that he received a request on the 3rd of August 2018 from the investigating officer of the matter, Colonel Swart from Mtansane Detective Unit, to process a single exhibit regarding a case he was investigating. He booked the exhibits from the Mtansane exhibit store booked out at about 8:45 a.m. At this point, due to time and to facilitate proceedings, the state applied to furnish the court with the report / affidavit drafted by the witness to assist the court to follow the evidence, to which the defense in respect of accused 1 and 2 had no objection. In paragraph 4 of the affidavit, the SAP 13 number is recorded as 699 of 2018. The exhibit the witness booked out was a single cartridge case sealed in evidence bag with seal number PA 6001796-106. He proceeded to process the exhibits in the crime scene laboratory at his office and compiled a photo album documenting the different steps that he had taken with the exhibit. He further confirmed that the photo album is correct and, according to his knowledge, unaltered. Photo 1, 2, and 3 depicts the exhibit bag as testified and visible in photo 2 as PA 6001796-106. Photos 4 and 5 depicts the single cartridge case, and 6 and 7 shows a fingerprint that he had recovered on the cartridge case. It is noted that the fingerprints are tested against the SUBS database and against the set of fingerprints that he received from the investigating officer. However, no match was found. Photos 8 to 17 show the acting DNA collection from the cartridge case, which, according to his understanding, was also not linked to any person. After completing his processes, the witness resealed the cartridge case in an evidence bag as visible on photo 19 and 20 with serial number PA 60002321818. On the same day, after completing his processes, the witness delivered a sealed reference bag to the Forensic Science Laboratory in North End, Port Elizabeth, and testified that whilst in his possession it was kept safe and not altered in any manner, and all processes he used were non-destructive and visual. The bulk of the photo album was submitted, being photos 1 up to photos 270, and as to photos 1 to 20 was submitted earlier during the evidence, the balance being then 21 to 2070, to 270 was submitted and accepted by court. With reference to paragraph 11, 12, and 13 of his affidavit, he was requested by the ballistic section of the Forensic Science Laboratory to process these firearms and ammunition for fingerprints. The witness confirmed that most of the firearms did not retain any fingerprints. The few prints he recovered did not match any person. This aspect does not require any further discussion by court, as the finding is clear. The witness continued and referred to the court to photos 126 to 131 of the photo album. The photos depict a firearm that he investigated. Photo 126 and 127 reflects the seal exhibit bag which the witness received and visible as PAR 00238-256, and photo 128, the actual firearm removed from the exhibit bag, and 129 reflects the serial number visible on photo 29 as CN SPA 24914. Then photos 130 and 131 shows the resealed firearm into evidence bag with serial number PAR 000-1252427. The witness testified that the selection of photos depicts the processes that he followed with each and every one of the firearms, where only this specific firearm was relevant to the case, being the said CNSPA 24914. It was processed under Mtansane CAS 0608 of 18. The said firearm was also marked with the following reference: Brighton Beach SAP 13/890/2018. As a point raised by the state, the witness testified that the cartridge case was delivered by hand by himself at the Forensic Science Laboratory in North End, Port Elizabeth. The witness confirmed that all the examinations performed by himself were conducted in room 608 at the Forensic Science Laboratory under supervision of a ballistic expert, Lieutenant Colonel Mgwadleka. The witness received the seal exhibit from Colonel Mgwadleka and left it sealed again with Colonel Mgwadleka. From the side of this witness, no further examinations were conducted with regard to the cartridge case or the firearm as mentioned. However, the witness received a request from Colonel Mgwadleka on the 22nd of January 2020 to assist him to video record a shooting demonstration. The witness tested the muzzle flash of the said firearm. He started the recording at 10:36 a.m. at a distance of 2.3 meters from the firearm at an indoor shooting range at the Forensic Science Laboratory. The recording had a digital file number P2U00371 and was approximately 2 minutes and 56 seconds in duration. After completing the video, he was requested to make screenshots or still photos from the videos and each one of the shots fired. The witness then completed a compiled photo album with the images, which he marked as shot 1 to shot 5 and handed it over to the investigating officer, Colonel Swart. The witness was further requested to visit Sisa Dukashe Stadium in NU2 Mtansane by Colonel Swart to assist with making or taking measurements and plot certain points at an area in Mtansane. This was done on 19 November 2018. The witness testified that the points and measurements were taken with a handheld Garmin high-sensitivity and GPS device, after which he had downloaded the data into the Garmin Street Maps as well as the Google Earth satellite program. The data and images are depicted in photo album marked as GPS Map 1 and 2 and Satellite Image 1 and 2. With regards to Satellite Image 1, it depicts a yellow, more or less in the center, 2 points A and B, whereby A is the area that was pointed out to the witness where the podium was approximately located during the incident, and B the area where the cartridge case was recovered. The distance between the 2 points measured 23 meters. The witness informed the court that these are not accurate measurements, as the precise location of the podium as well as the precise location of where the cartridge case was found is not known to him and was pointed out to him by Colonel Swart, and also requested that it should be viewed with caution. He also obtained measurements to the nearest house located from the area and which was visible, marked as reference point 7, and the distance between point 7 and the point A was plus minus 113 meters. The second point was also recorded and visible on satellite image 1, right-hand side of the stadium, marked with a black dot marked as Funulwazi SP School. This point was marked reference 6, and the distance between point A and point 6 measured approximately 142 meters. In essence, that concluded the function of this witness pertaining to this matter. As to estimations regarding questions pertaining to ammunition, etc., he had elected to leave such aspects to the ballistic experts unit to answer. Cross-examination by Advocate Holders on behalf of Accused 1. Confirmed he received a spent cartridge case on 3 August 2018, sealed in exhibit bag marked PA 60017961006, and that after he examined the spent cartridge and photos were taken, it was placed in a Ziploc bag and then resealed in exhibit bag, evidence bag, PA 600-232-1818. As to what he had done with the original bag, PA 600-1796-106, the witness explained that it was stored in their dockets and it is still available in his docket with him in court. He explains that it was done in this fashion as there was a possibility that further examination may be needed. He confirmed that all fingerprint comparisons were negative and again explains the purpose of the Ziploc bag was to preserve possible evidence. When they start processing an exhibit like the one in question, they do not have all the knowledge of the case or investigations. Therefore, the proper procedure after the DNA was lifted is to store it in a Ziploc and from there into an evidence bag. Further, that resealed means it is a new evidence exhibit bag that is used as a bag can only be used once to secure tamper-proof. Therefore, once the bag is sealed and opened, it cannot be used again. It ensures that the seal remains intact. It was placed before the witness that it is normal practice to seal the old, now damaged forensic bag into the new bag, and whether he was aware of this practice. He confirmed that indeed it is correct as per page 25 of the record. However, that yes, that is in practice, but it is not a standard operating procedure. The witness confirmed he had the spent cartridge case in his possession on the 3rd of August 2018 from 08:45 to 1600, so therefore 4 p.m. in the afternoon. With regards to paragraph 14 of the statement, the witness testified that he had not had sight of the photos of the stage or podium and relied on the investigating officer to point out the points to him. The witness confirmed that he agrees in order to produce accurate measurements, one will need to know the size of the items, stating it is why he indicated to court and cautioned the court that it is an estimation and definitely not accurate measurements. On further questions, the witness confirms that the stage shown to him depicted on the photos are indeed large in structure. He also confirms that he was not aware of the other structures as depicted on the photos, yet been shown by the defense in court, which includes the catering tents, etc. He confirms that he is able to see the white tents or structures on both sides of the stage. However, at the time of measurements, the witness had agreed to and had, from the onset of the examination, confirmed to be an inaccurate assessment or observation by the defense in that for a spent going too fast and I'm missing a full stop or a comma here. Just a minute. The observation by the defense placed to the witness is that for a spent cartridge to travel from a stage to where it is said to be found would have had to travel through several items, and the witness had confirmed that indeed that would have assisted him in drafting a more accurate assessment of the observation. It was put to the witness that the ejection range is a medium of 2.4 meters and 1.2 meters back, which the witness confirms as correct. The witness confirmed that a spent cartridge or ejection of a spent round will never travel or be 23 meters as indicated on his estimation of the measurements. The witness then explained that per record verbatim, page 32 of cross-examination, the question of the direct ejection and the travel distances traveled will have to be answered by a ballistic expert before the court. As a crime scene reconstruction expert, I would he would like to point out to the court that a direct ejection from the firearm to the surface it was found is not the only way that it is possible in this case. It is also possible that the cartridge case could have been picked up and then carried to that area from the firearm, or it could have just been dropped from a completely different area from where it was found. It was then placed before the witness that if he concedes anything is possible, it could have been placed there 6 months before the time. Cross-examination by Advocate Matthews on behalf of accused 2. The witness was requested to refer to photo 4 of the photo album, and it was put to the witness that it displays a very unique mark on the cartridge case, which the witness confirms and referred to as damage to the cartridge. It was further put to the witness that Exhibit A, photo 4, does not reflect or show any mark on the cartridge. The witness replied and confirmed that the section visible on the photo, the ejector mark, is not visible there. The witness also confirmed that he referred to the mark as damage or a scratch mark, even a prominent scratch mark. The witness was referred to photo 129, which depicts the firearm CN SPA 24914, and photos 128. The witness confirms that photo 128 is a photo of the complete firearm, and photo 129 is a close-up photo of the serial number already placed on record. It was placed before the witness that the firearm in question does not have a fold-up butt, to which the witness replied, "It is best answered by a ballistic expert." Advocate Matthews put to the witness that it does not take a rocket scientist to establish this fact. And the witness was asked to look at photo 140 and continue to say, "Your training as a forensic expert, does it not include being able to identify firearms?" The witness replied, "Identify?" And it was put to him, "Yes, firearms." The witness explained that is a discipline on its own. However, he was told, "Well, just look at the photograph 140 and photograph 128 where the butt pushes in and out. And I want to put to you that the CN SPA 24914 does not have a fold-up butt. It has a butt that pushes in and out. You can expand on it and push it back in. Do you dispute that?" The witness replied he had no idea. Exhibits submitted at this point, the section 212 at 51 of CPA at 51 of 1977, submitted as Exhibit D, key to album Exhibit D1, photos 1 to 272, image of the simulating shooting photos, Exhibit 1 to 5, marked Exhibit 3. I know there's Exhibit D4. I'll place that on record tomorrow. Sure. Okay. Let me just endorse the charge sheet. Will we have the same arrangement between the state and the defense that the media may set up ahead of time so that there's no delay, or will there be an objection from any of the parties? I think that is so. The media, if you are willing, you are welcome to do it as early as possible for us to proceed. Just want to endorse the court book. Accused 1 and 2. I have tried by all means to read as fast as humanly possible, but the time has caught us, so the matter will continue tomorrow, and I am confident that there will be sufficient time for judgment to continue. 30 September, you are both on bail, and bail is extended, and warned to be present in court to proceed by 9 a.m. Thank you. Oh, please, sorry. You are excused, then please stand up. The other two charges, I'll endorse in my office so I can sign it for the court. Okay, I'll just endorse the court for so long it's fine. Yeah. Thank you.